Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us our fabulous co-counsel who is in our Wichita Falls office, Richard Sutherland. Welcome, Richard.
Thank you, Melinda.
We're so glad to have you here.
Well, glad to be here.
I know that you are on the Forms Committee for the State Bar. Is that correct?
Yes, Family Law Practice Manual Form Committee.
And you focus on retirement.
Well, that's one of the chapters I focus on, but yes, I write the chapter on retirement.
Well, I think sometimes people get a little confused about this area. There's different types of retirement that we will see in a divorce case, correct?
Correct. There's typically three kinds of retirement that we're typically going to run into. We're going to run into plans that are governed by ERISA, Employment and Retirement Income Security Act. They're commonly known as defined contribution or defined benefit plans.
Give an example of one of those.
A defined contribution plan is any plan where the participant has a separate account set up for them. Mm-hmm. The most common are 401ks, 403bs, employee stock option plans, profit sharing plans, things of that nature. A defined benefit plan is any plan that's not a defined contribution plan. It's what we used to think of as pension plans. They're typically annuities.
Mm-hmm. And we used to see a lot more pensions, and now it seems like we see a lot more 401ks.
Yes, pension plans fell out of favor. They became a little more difficult to administer. With bankruptcies of certain companies, for example, when American Airlines filed bankruptcy, that threw their defined benefit plan into bankruptcy, and then that triggered the pension guarantee benefit corporation insurance plans. It just made it more complicated. Defined contribution plans are easier to administer.
Understood. Okay, so carry on.
So if we have an ERISA plan, then we're going to need, ERISA is a federal law passed in 1974, and it governs privately funded retirement plans that don't have any tax paid on them, so they're pre-tax plans, tax-qualified plans. And in 1984, Congress amended that, passed called the Retirement Equity Act, and that created a gizmo called a Qualified Domestic Relations Order, a QDRO. You can't divide an ERISA plan without a QDRO.
Okay, so I want to amplify what you just said. I had a client recently who said, hey, he's just going to write me a check out of his 401k to divide it, meaning her husband, before the divorce is final. And I was like, whoa. You can't divide it yourself. You have to use what you just said, the QDRO.
Under your example, he could have written a check if he was entitled to borrow money against his 401k. But if we're just dividing it as it existed at that time, we're not planning for future gains or losses or increases, that would do it. But if you're trying to divide the plan so that you can have a benefit of increases going forward, then you're going to need a QDRO.
And that's what most people do, right? They
Correct.
Want to have the market conditions applied to both of their portions.
That's correct. The problem that we see is that some practitioners do not do retirement plans. So we get decrees that reference a QDRO as Exhibit A. But there is no Exhibit A. Okay, so now...
They're hopeful there's going to be a QDRO that someone else is going to draft, maybe.
And so that necessarily means that in order to get the QDRO, now we're in post-divorce, we're in Chapter 9 proceedings, but the problem can be exacerbated if we have a defined contribution plan. Let's say we have a 401k plan. Mm-hmm. And let's say that our practitioner, who doesn't do these orders, isn't aware of steps that he needs to take to protect his client. For example...
And this is during the divorce.
This is during the divorce.
Yes.
So the first thing that the attorney ought to do, whether he's going to do the order or not, is do some preliminary discovery. All right, well, what does he need to find out? Well, first thing he needs to find out is there a plan? All right, now how does he find out? Well, most people, if they have a 401k, know that their spouse has a 401k because you typically get a quarterly statement.
Yes.
But if you have a defined benefit plan where you don't get a statement and there's no...
Like a pension, that you don't always receive a statement.
The employee doesn't pay into the pension. So how do you find that out? And in a lot of the older companies still have both a defined benefit and a defined contribution. So get a copy of the W-2. Get the employee's W-2. Look in box number 12 and see if there is a D. If there's a D, it tells you there's deferred compensation.
Oh, that's great. There's so many things we can get from people's tax returns and their supporting tax return documents. That's a great example of it. Okay, look for D.
So if we have the D, now we don't know what kind of plan it is, but we know it's a deferred plan. So now let's, in our initial discovery, what we want to see is, let's get a copy of the Summary Plan Description Booklet. Now, that's a term of art. It may be that the employee gets that as a separate booklet. More often than not, it's contained in an employee handbook. So why do we need that? Well, that's going to give us the name of the plan. It's going to tell us the name of the plan administrator, the plan administrator's address.
We need that because that's who has to get the quadro. Right?
Well, that's who has to get the quadro, but let's go back to if we have a defined contribution plan.
Okay.
Let's suppose that we have a 401k. All right, we've identified through our discovery we have a 401k. We've gotten the Summary Plan Description Booklet. Now, practitioner, you need to send a letter to the plan administrator with a copy of the divorce petition and the standing order or the injunction. Now, that's not binding on the plan administrator, but it puts the plan administrator on notice that there's a pending divorce case, and so they are not going to allow the participant to borrow money against that 401k, which, if you don't put them on notice, can reduce the value of the 401k for division purposes.
Yeah, sometimes they can borrow up to 50%.
Yes.
And that could be a lot.
So we want to get that. We also want to get a model form quadro. Now, model form quadros are always going to be prepared to benefit the participant. That's the employee who participates in the retirement. Whether we do the quadro or not, we want the model form quadro. And we want, if we're going to have someone else do the quadro, we want them to do it before we enter the divorce decree, because we want to get pre-approval of our quadro. Most plan administrators will give you pre-approval. Some won't. There is no standard form for quadros, so you need the model form to look at it.
And when you say the model form, that means the company who the person is employed with, that plan administrator, they've already gone through their own internal creation of this form.
The plan will have an attorney. Now, that attorney may not be a Texas attorney. That attorney may be in Ohio. Okay, but it is the model form. Now, almost all model forms in ERISA plans can be amended, revised, adjusted, as long as you don't violate certain specific requirements of ERISA. For example, you can't require the plan to pay some kind of benefit that's not permitted by the plan. You can't.
We're still under the rules of the plan,
right? And you can't require the plan to pay a greater amount through some actuarial calculation than the plan would ordinarily pay. You can't direct the plan to disregard a prior quadro so that it can honor your quadro.
Oh, that's interesting.
So you can't do those things. But now we've got the preliminary information. We want to notify the plan administrator. We want to get this model form quadro so that if we're hiring someone else to do it, they can do it. We can submit it to the plan administrator prior to our offering the decree so that it will be preliminarily approved. It can't be finally approved because we don't have the date of the divorce, but we've got the calculations and so forth in the verbiage. Then we avoid the problem that you get into if we don't do that. If we don't get pre-approval, And we just go ahead and we get the decree signed, we get this quadro signed, and we send the quadro off to the plan administrator, and they reject it.
Yeah.
Now you have to file a brand new lawsuit under Chapter 9 to get yourself a viable quadro, and you're probably going to have a very unhappy client that learns we have to file a brand new lawsuit in order to get an enforceable order.
Because this judge only, the judge who signed the divorce decree, only has jurisdiction to sign things for so long after that.
Well, no. If we have a quadro, that we're authorized a quadro, and we divide the retirement plan, but we don't have a quadro, we can still come in under Chapter 9.
Mm-hmm.
We can file a lawsuit to get an enforceable quadro.
Understood.
And the legislature amended the law this year so that we can now get attorney's fees. We didn't used to be able to get attorney's fees, but we can now get attorney's fees to do that. The problem is the client doesn't understand why do I have to file another lawsuit to get the same order I was entitled? Why didn't we do it all the first time?
Yes, so that would be the better practice. You mentioned that sometimes lawyers like myself don't draft the quadro themselves. Maybe they hire a specialist to do it, but you do draft them.
Yes.
And that's because you have the knowledge. You've really studied on the topic. But there are some instances where people enter the decree and then nobody ever drafts the quadro, and years later somebody wakes up and says, oh, I think I was supposed to get part of that.
And I see that frequently. I see people that come in and they have a divorce decree that either refers to Exhibit A, which was never done, or it talks about the quadro to be signed, which is never done. You can still go in under Chapter 9. You can still get your quadro, but imagine a situation where the parties don't live in the same state anymore. Imagine where somebody has moved to a different state. And it can become more difficult to get those documents that you need because you're always going to need the summary plan description booklet. You can't do a quadro without one.
Okay, back to that topic. One thing that I like to do sometimes is send a third-party subpoena to the employer and say, I want to know all this guy or gal's benefits, and I want the summary plan documents. Because sometimes people don't even know they have a pension because, to the point you made earlier, they don't receive a statement.
Well, the problem with that is under federal law, the plan administrator is required to respond to the participant, but not the alternate payee. And when you deal with an ERISA plan, you can't sue the plan administrator. You can't get the plan administrator in federal court to do something. They're exempt from that. So if you're in initial discovery, you want the participant to get that information. Definition of possession, custody, and control.
Absolutely.
They have it. They can get it. They can write the letter. But typically, it's going to be in the employee handbook.
Yes.
And so if you were to tell your client that you need, if you represented the participant, they may not know what a summary plan description booklet is, but they typically have an employee handbook or a retirement handbook.
Call HR.
Yeah, call HR and they'll get you that information. So the key things for people who don't do the orders, do your preliminary discovery. Figure out what kind of plan you have. You also want to know if the plan has predecessor plans so that the plan name has changed.
Oh, good point.
So it was Plan A, now it's Plan B, but Plan A got merged into Plan B. So we want to know if there are predecessor plans. We want to get this summary plan description booklet, and we want to get that model form quadro.
To your point about predecessor plans, I just had one where they actually not only had a predecessor plan, there were now two plans.
Yes.
So this person had two pensions, and they called one the XYZ pension, and they called the other one the XYZ pension with a
two.
Right.
Yeah. Or the premier plan.
And it would be very easy to just not discover that and have the person say, well, here's my pension, and maybe overlook that there's two pensions we need to be addressing.
Also, when you're going to get the person to draw up the quadro, that person you need to understand that these aren't fill-in-the-blank documents, and that more often than not, the model form quadro is prepared by the attorney for the plan to protect the plan participant. So you want only the alternate payee's lawyer should draw up the quadro. And you can make changes in them, but you typically have to if the attorney for the plan is in Ohio and doesn't know anything about community property law or separate property. They're not going to have that verbiage in the model form quadro.
That makes sense. Absolutely. Well, and we have situations where some companies don't have a model form.
The company doesn't. The plan administrator does. That's the key. You've got somebody that I work for, Vetratex Glass. Vetratex Glass doesn't have a form. Prudential has the form.
Oh, it's a good distinction.
Again, we want to know in our discovery, we got to get the summary plan description booklet because we need to know who is the plan administrator, not simply who do I work for, but who administers the plan.
Yes. Okay, let's talk about military.
Okay, military retirement is a horse of a different color. So we're not going to use the same terminology that we do in ERISA. We're not going to use quadro. We're not going to use participant. We're not going to use alternate payee. We're going to use Military Retirement Pension Division Order, MRPDO. We're going to use service member. We're going to use spouse. So there's two ways that you can divide military retirement in a divorce. There's the 10-10 rule. The 10-10 rule is triggered under federal law, the Uniform Former Spouses Protection Act. So what that says is, in order to be eligible for the Defense, Finance, and Accounting Service, they're the people who physically implement these orders, and we're now in federal land, so we're in acronym land. Everything we do is an acronym. So in our MRPDO, to get DFAS, to do anything, we have to qualify. That means we have to have been married for 10 years, during which the member had 10 years of creditable service, and be married for 10 years. Okay, so what if we were married for 9 years and 11 months at the time of the divorce? Well, we don't qualify.
Is the date we're looking at the date of the filing of the divorce or the date of the finalization of the divorce?
The date of the finalization of the divorce.
Okay.
So let's suppose that we have one that's governed by the Uniform Former Spouses Act. All right, so what we're going to do there is part of our discovery, again, whether we do the order or not, the key thing we have to have is what is known as the High 36. Now, I'm assuming at this point that the member's not retired. The member's still in service. The High 36 is the highest 36 months of basic pay. It's typically the last 36 months, but it may not be if there's been a reduction in grade or rank. So we have to know, did this person have a reduction in grade or rank? Because if they did, we're going to go back to that period to figure out your High 36. Okay? So let's take an example of what we're talking about. So we're going to divide the retirement. Under federal law, we can't get more than 50% of the service member's retirement. So we're going to have a formula, a fraction. The formula is going to be 1/2 times a fraction, the numerator of which is the total whole months of creditable service earned during marriage. The denominator, if our service member is not retired, is unknown.
Okay.
Multiplied by the High 36, but you have to understand, let's suppose our High 36 is $5,000.
Okay.
If the service member serves 20 years, it's half that amount. It's not $5,000, it's $2,500. So we have 1/2, now we have a fraction, we got the numerator. Now when he retires, we have the denominator. So how do we do that in the divorce? Well, In the divorce, what we know the high 36, we know the total months of creditable service earned during marriage. We don't know the denominator, and therefore we know we have to have a Chapter 9 proceeding after the divorce to come back in. So what do we want to do in the divorce to protect ourselves?
Yes.
Well, we want the high 36 for sure. We also want the order to provide for, in your divorce decree, provide for cost of living adjustments. Provide for the survivor benefit premium payment. If you don't put those in your divorce decree and you wait to do your Chapter 9 proceeding, you can't get those because that is a substantive change to the decree, and under Chapter 9 of the Family Code, that's an unenforceable order. And now you don't have the COLA, and now you don't have the survivor benefit premium.
That sounds very important.
So you have to make sure that we get all of those things done. Now, if we have somebody who's retired, it's much easier. Well, we're going to get a document called a retiree earnings statement. Now, you see forms that say that they're ordered to provide this form by mailing a copy. They don't get them by mail. Everything's online now. They can go online and get this information.
Yeah, that's convenient.
Now, if you have somebody who is not yet retired, you want to get what's called leave and earnings statement, an LES. An LES is going to tell you what their basic pay is. That's what we're looking for, is the basic pay. If we know their rank and grade, and we also need to know the starting date of creditable service. Once we know the starting date of creditable service, that's when we're going to start measuring our anniversary dates for our high 36. And a common mistake is people say, well, okay, I've got the last year, so I'll just go multiply that by 3. That's not true, because probably his pay has adjusted over those 3 years and adjusted with COLA increases.
Oh, so yeah, it's not going to be a straight number.
It's not going to be a straight number.
Mm-hmm.
So you want to get that done. Now, the military retirement pension division orders can also be affected by the number of years of service. So in my example previously, we had someone who had retired at 20 years.
Mm-hmm.
Let's suppose he retires at 25 years.
Okay.
Now it's not 50% of the basic pay amount. It's 62.5% because we get 2.5% for each whole credible year of service beyond 20. Now, I'm not talking about the half that we're dividing for the spouse. I'm talking about of his high 36 or his retired pay, what amount is the retirement amount? Normally, 20 years, that's 50%. But we're going to add 2.5% for each whole credible year after that. So if we had 25 years, now we're up to 62.5%. So we need to know that.
Mm-hmm.
Okay?
That's a big difference.
Now, all of this sounds very complicated.
It does.
But all of this is contained in federal statutes. And all of this, you can find information about this by going to government websites. You can go to military retirement. They will tell you. They will cite you to the federal statutes. A common mistake that I see, that I've seen people make, is in calculating the whole months of creditable service. So the way it actually works is if we got divorced on November 25th,
mm-hmm.
then the last whole month of creditable service was October.
Makes sense.
Federal law says to disregard fractional parts. But what I see is people add up the total number of days and divide by 30.
Oh,
and that's not right. That will not work because that is not consistent with federal law.
Yeah. But the federal law is not a secret. It is available.
Right. And then the second way to divide military retirement that's often overlooked is if the 10-10 rule doesn't apply, it is still a divisible asset in a Texas divorce. The court can divide it. More importantly, under Texas law, the court's not restricted by restricting the division to 50% of the amount. There's a Texas Supreme Court case that says it can divide it any way it wants to.
A lot of discretion.
Lots of discretion. Now, the problem you're going to get into is enforcement. How do I get it? You're going to appoint someone a constructive trustee. If the person is, living around near where you are, you may have a chance of getting it.
Yes.
You probably, under Chapter 9 of the Family Code, are going to have a problem because you don't have a specific amount, and the amount is not in existence at the time of your divorce decree.
I see. So it might be a paper reward only.
but what you might want to consider is, okay, I'm not going to get it.
Mm-hmm.
What is it worth?
Value it.
Why don't I
else.
value it and offset the value? Because I can still calculate a value.
Yes, absolutely.
And I can do an actuarial calculation as to that value. And now I have a value for my divorce that I can offset against another asset.
Yes, that sounds like a great approach. What about teacher retirement? I think you and I talked earlier. That's an area where we both have seen a lot of people make mistakes or misunderstand, because what the teacher retirement gives you, it looks like on its face it's giving you a value, but it's not really the right value.
All that annually, the participant, the teacher, is going to get a statement of how much money has been paid in. And that's not the value.
And it's dramatically different.
It's dramatically different. So it uses a formula. So the formula is we're going to figure out the total number of years of creditable service. We're going to multiply that by 2.3%. We're going to take the 5 highest years of salary. All right, so let's assume we've got someone of 9 years at the time of the divorce. We multiply that by 2.3%. Now we've got 20.7%. We get our 5 years average. We multiply that by 20.7%. And now we know what the annuity value is for a year. But if we do an actuarial calculation, then we come up with a present value of the annuity benefit. But that is a common mistake, that people just look at that amount.
And you might need to hire an actuarial expert to help you calculate that, but they can do it pretty quickly.
If you do, if you're working with somebody that you work with a lot that says you've got a person does business valuations, let's say, so CPA does business valuations, and you do work with that person frequently, you can call them on the phone and say, can you do an actuarial calculation? They can spit one out in an hour.
Yeah, it's not complicated, but it is, you need a qualified person.
But one of the things that's important about state of Texas plans is that they're all different. And in some plans, you can't move a comma or they'll reject the plan. In other plans, you can adjust for things. Some plans, Texas Municipal Retirement System, for example, I recently did one with them. They were exceptionally helpful. I worked with the attorneys on their staff, and they got me the information I need. They showed me how to make it a viable, workable order. So with state plans, again, go online. They all are online. They all have information. Now, you may have a problem if you represent the alternate payee. You don't represent the participant. But you can't access that information because you don't have the ID. So where are we? Well, we're back to discovery. We're going to get that information through discovery.
And give examples of when you would be dealing with a state plan. What is the person doing for a living, for example?
Okay, for the Texas Municipal Retirement System, this person worked for the city of Wichita Falls. He's a city worker. He's in that plan. If the person was a deputy sheriff, then he's going to work for the county and district retirement system. So and if you have someone, and you may have someone who participates in multiple plans. Let's suppose you had someone who was an assistant district attorney, and he was in one plan. They became a judge. Now he's in a different plan. He's got 2 retirement plans. So you want to know the information about those plans. Now, in all of these things that we've talked about, there are resources. For example, if you're dealing with ERISA and you say, I just can't deal with that. I mean, it's tax related. I don't understand any of that. A very simple starting point is if you have the State Bar of Texas Family Law Practice Manual, there is a book that comes with those forms called practice notes. Those practice notes are updated every year.
Oh,
They're
that's
edited every year with current case law. You can go there and get an overview of what you need. Okay? If you're trying to understand ERISA plans, CLE articles from the State Bar, particularly ones written by Charlotte Bradshaw, are exceptionally good. Get those. That will give you some, at least basic information. Military retirement, there are websites. You can get it from the government to do that. Also, again, the practice notes. Now, because I'm involved with Chapter 25 of the practice notes, and I write and edit that, I have a whole list of online resources that you can go to. Just look at the chapter notes, and it will tell you where to go to get that information.
Richard, this has been so helpful. So you practice out of our Wichita Falls office. What areas do you cover in Texas? Where all do you work?
Anywhere. I prefer,
You're available.
I prefer not to go to the Metroplex. I've been doing this. My coming year will be my 50th year.
Oh, that's excellent.
So the notion of driving in the Metroplex from living in a small town doesn't have much appeal to me. But virtually anywhere.
Well, this has been so helpful. I think this is an area of confusion, and you made it sound doable for the average person trying to deal with retirement. And definitely, whether it's a lawyer listening or a potential party in a divorce listening, they need to be aware that this needs to be explored enough that we do it the right way in the divorce.
That's correct.
Thank you so much. And thank you for listening. We really appreciate it. And we'll see you next time on the Melinda Eitzen Show.